The agenda piece is obviously employment law legislation. We were blessed with an array of propositions of changes with the new government, and it's really interesting because you will see it as we go through today. Some of it is already falling off the page because some of the proposed changes obviously will bring a lot of complications. So while some are not getting to see the longevity in turning into law, others will. So today is about preparing you for that. So we're going to talk to you about immediate changes and the Employment Rights Bill, what's being proposed there. The changes to existing powers and non-legislative routes. Changes under the Equality, Race and Disability Bill and the Employment Rights Bill recap. There will be questions at the end for us to take, as I said, so be patient with us, allow the girls to run through, and we will make sure that we answer all the questions at the end. So without further ado, let me introduce you to your guests, to your speakers today.
Thank you, Alison. So as Alison shared, we are going to talk through some of the employment law changes that have happened, are imminent, are still at different stages in Parliament. And the aim is to leave you informed of your responsibilities and what you need to do to be compliant. So we obviously, as employers, you want to make sure that you're complying with the legislation, but also ensuring that you're maintaining your employee trust and satisfaction, and that they feel that you are confident in all that's required of you as an employer. Next slide, please, back. Brilliant. So first of all, let's talk about the changes that have just happened or are happening this month. You will be aware that in January, biometric residence permits have changed. As employers, you must conduct right-to-work checks on all employees. Previously, you may have had to check biometric residence permits, but these have now been replaced with e-visas. Employers must ensure that effective employees have applied for their or received their e-visa. If they've lost their biometric residence permit, it doesn't affect their immigration status, but it will affect their right to work. So you do need to make sure that any employees that have a biometric residence permit, that you're processing them correctly and making sure that their right to work checks are completed and you store that information safely for should you need it in the future. Another change that has happened in February was that something that might not affect you at the moment, but you just need to be aware of if you do any work in EU markets, and that's of the AI changes. So this AI laws come into the EU that for companies that affect that deliver products into the EU market from the UK, and that includes AI outputs for decision making. So if there's anything that you use AI-wise and you do trade in an EU market, please make sure that you're up to date with those changes. There are more changes in that law due for the UK in the future, but Kim will talk to you a bit more about that as we progress through this webinar. April, as you'll know, is always a big change for employment law. So we're going to talk in a bit more detail in a second about neonatal care leave, which is a new law that comes into effect on the 6th of April. And this provides statutory leave and pay for parents with a child in neonatal care across the UK. The minimum wage rates have increased, which always happens in April. I'm sure your accountants have made you aware of these changes to statutory pay rates, but the living wage is now £12.21 per hour, and all the other age brackets have changed as well. So make sure that you're up to date, paying the right amount. You don't want to be caught underpaying minimum wage. So if you do any sort of deductions or there's different settings with regards to overtime, etc., please make sure that you are not paying below minimum wage when it comes to an average payment for your employees. Benefits rates have also increased, so the statutory amount has gone up to £187.18 per week. So that is for the likes of maternity, paternity, adoption, shared parental leave, etc. The statutory rates also gone up for sick pay, and the lower earnings threshold limits increased. So again, your accountant should make you aware of these elements, but the best practice is always to write to employees who are receiving a statutory payment. And so we'd recommend that you write to them and they know what to expect when. So, for example, if you've got somebody that's on long-term sick and their rate is going to change, then we'd suggest writing to them just to make them aware of the statutory amount that's remaining and what the pay that they can expect to receive will change to. You should also, again, be aware from your accountants and also the news, because this has been a big topic, is that national insurance contributions have increased. I'm sure as employers, you're very aware of that because it does make an increase to your costs. So I won't go into too much detail on that. But all I would say is just make sure that you know you're aware of all these changes and that you take necessary action to ensure that you're compliant. So, as I said, we're going to talk in a little bit of detail about neonatal care leave. I will apologise that some of the topics in this webinar are quite hard hitting, but that's just because of the changes that the government are making are to things like bereavement, neonatal, etc. So just to make you aware, there are some topics that we're going to talk through that are a bit heavy. So the Neonatal Care Act was introduced it's coming into effect on the 6th of April, but it's an act from 2023, and it introduces significant new entitlements for employees. It's not just for women, it's for all parents with a baby who is in need of neonatal care. And as employers, it's crucial to understand and how these changes can support your employees effectively. This new entitlement allows parents whose babies need extra care, whether in hospital or at home if they've already been hospitalised, to a further 12 weeks leave on top of their other statutory leaves, both, for example, maternity, paternity, adoption leave. It's defined in law as care of a medical or palliative kind lasting for at least 7 consecutive days, which usually starts within 28 days, beginning the day after the child's birth. The medical care may be received in hospital or out of hospital, providing the child originally was an inpatient and the care is under the direction of a consultant. It covers babies receiving palliative care or end-of-life care as well. What I would say is that what you need to do with this information is just make sure that you proactively address these changes, you review and extend your family leave policies to incorporate neonatal care leave and pay, that you educate your line managers so that they know what to do when the employee rings and says, I've had my baby, but they're in hospital. And make sure that your employees know what their rights are with regards to requesting leave and pay. This one's a little bit more tricky than maternity because most likely they've not preempted that the baby's going to go into hospital. You know you're going to have a baby, so you know you're going to take maternity, paternity, adoption leave, whatever that looks like. But with regards to this one, it's often going to be something that you're maybe a little bit on the back foot for. So we are always here to support you with these situations. So if an employee rings up and says that the baby is in hospital and you go, okay, I think there's something we need to do here, pick up the phone and talk to us and we can help you with that. We will provide you with the policies over the next few weeks with the changes if you've not already got them. But yeah, we are always here to help with these sorts of situations because we appreciate it's not something that happens every day. So you're probably not going to have the practice of using them. So the Employment Rights Bill. I'm sure you've all heard of the Employment Rights Bill by now. This legislation is currently at committee stage in the House of Lords, so it is progressing, which is good news. There's been devised to deliver the government's Make Work Pay plan, and it is set to transform these listed areas of employment law. So there's quite a few that obviously you as employers need to be aware of. Some of them will be big changes, some of them will be small changes. Some of them we're not sure what they look like fully yet, but we will provide more details as we progress through this webinar and cover each topic. There isn't a confirmed date for these amendments, but if they will be implemented if the bill continues at its usual pace and isn't referred back to the House of Commons, then it will potentially gain royal assent this summer, which does mean that some changes may come into effect in October this year. So that is quicker than originally suggested. Originally, the suggestions were October next year. We don't expect that everything will happen this year, but some things could happen as quickly as October this year. So we just need to be aware that they are on the horizon and that some things will be happening sooner rather than later. Another way that the government makes changes is through existing powers and non-legislative routes, meaning that they can typically be implemented at any time. The flexibility of this allows the government or relevant authority to act without the need for lengthy legislative processes with regards like how the bill is progressing at the moment. And this enables faster decision making and adaptation of evolving needs. A main change that was proposed through this method was the right to switch off. However, this has been omitted and is not going to become a statutory right. So that means that there's no statutory requirement that you allow your employees to disconnect from work or outside of their working hours. However, we do suggest that if you can facilitate this for your employees and allow them to switch off from work outside of their working hours, it's positive in regards to an ethical decision, but it will also strengthen your employee relationship because you're giving them the work-life balance that most people crave. So I'm going to pass back to Kim now, who's going to take you through some more of the information that you need.
Okay, so the changes under the Equality, Race and Disability Bill is actually separate to the Employment Rights Bill, a separate bill in itself. And as of the 18th of March, public consultation was launched to gather input on how to implement these reporting requirements effectively. So it's currently out to consultation. The consultation is scheduled to close on the 10th of June. We anticipate any of these changes to come into effect sometime next year, but it's basically introducing a right to make equal pay claims to Black, Asian, minority ethnic and disabled workers. So it's introducing more race equality across the board, basically. There will be a requirement for employers with at least 250 employees to report on the ethnicity pay gap in their organisations, and the same will apply for a disability pay gap as well. So employers with over 250 employees and public sector employees are likely to be affected by this. But again, we're not expecting it to take effect until sometime in 2026. We'll keep you abreast of the changes. Trade union rights. So again, the government is trying to simplify trade union recognition. They're trying to encourage employers in the future to put in terms and conditions that the employee has the right to join a union. So when you're issuing your written statement, also known as your contract of employment, to your employee, you need to let them know that they have the right to join a union. And you're also required to regularly remind workers of this right. So in terms of regularly reminding workers of this right, we're hoping that the legislation explains how frequently you need to remind your employees of this right. And it's also a case of unions are going to be able to access workplaces. So for recruitment organisation purposes, they'll have the right to come into the building and meet with their members. And again, we expect these changes to take effect sometime in 2026. But as some of this is quite simple, it could be early 2026 rather than autumn 2026. But again, we'll keep you updated of the changes. And this is a big one, isn't it? This is the one that everyone's been dreading, the unfair dismissal. So the bill is talking about replacing the 2-year unfair dismissal qualifying period with a new statutory probationary period of up to 9 months. This is still limited to employees, despite previous references to workers. There's a lot of debate as well going on regarding the probation period, i.e. if you don't have a probation period, do you still have to have the ability to dismiss somebody in 9 months? So we're waiting for further information about that. But in the meantime, it's a good idea to look at your recruitment processes and ensure that it aligns with the new framework. Look at your induction periods, look at your employee handbooks, look at your contracts of employment and your probation and performance management. And the probation and performance management is going to be the key to how you manage employees who aren't performing going forward. So we're anticipating that you still will be able to get rid of employees that aren't up to par, but you will just have to be extremely robust in your processes. So it's a good idea to update them beforehand. And again, we're awaiting further detail on this, and we don't anticipate the changes coming into effect until autumn next year, but we will keep you updated as and when this happens. So sick pay. We're looking at statutory sick pay becoming a right from day one of illness. So currently you have 3 waiting days that you have to wait before you're eligible for sick pay. The government is talking about scrapping those waiting days so you get it from the first day that you're ill and also from the start of employment. They're also going to take away the lower earnings limit band. And this follows on, in terms of the right from day one of illness, this follows on from what they did during COVID-19. So during the pandemic, they scrapped the waiting days then and made it that you could get it from day one. So they're saying that, you know, going forward, they want to see this applicable universally. Again, we're expecting the changes to come into play in 2026 sometime. In the meantime, you can brief your managers and employees, mention that this change might be coming in. It's highly likely it will. Review your policies and documents and engage external providers. So make sure your payroll's aware of this potential change going forward. I'm going to hand you over to my colleague, Rowena, who's going to talk about fire and rehire now.
Thanks, Kim. If I say P&O ferries, you'll probably all remember the large case of 2022 where fire and rehire sparked widespread criticism. That is obviously when fire and rehire goes really wrong, but this is why the government has decided to reform this. So the bill aims to restrict employers from using fire and rehire practices, which involves dismissing employees and then rehiring them on new, less favourable terms. And what that means is that dismissals due to employees' refusal to accept contractual changes will be considered automatically unfair, unless you as an employer can provide evidence of financial hardship or that the contractual changes were unavoidable. So what does that mean and what do you need to do? This is normally used when you need to make a contractual change. So, for example, you want to change your sick pay, company sick pay to statutory sick pay, or you need to change something else with regards to your contract. You normally consult with your employees around that, provide them with a contract. If they don't agree with it, then and you can't reach a resolution, then you would be issuing them termination on their current contract and offering them the new contract, which is how it works as regards to fire and rehire. That is the bit that's going to be the problem. So employers that wish to change your terms and conditions must continue to consult with your employees, but once the bill's passed, the employee can refuse the new terms, and where you'd previously end their current employment and force a new one, that will be automatically unfair. What we'd suggest doing at the moment is if you need to make any changes to your contract or you're planning on using the practice of fire and rehire, you need to stay informed of what's going on with these consultations and the proposal, just to make sure you know what your requirements could be. And employers who unreasonably fail to comply with the code could face an uplift of 25% on awards at tribunal claims. So it's going to have a hefty fine if you don't get it right. So what I would say is if you know that you need to make some changes to your contracts, talk to us now, or as soon as you know that you need to make changes, and we will help you navigate this process and see what we can do to make it as smooth as possible. Hopefully you are not making any less favourable terms and you shouldn't have any issue with changing the contracts, but sometimes these things are unavoidable. So all I would say is talk to us and we will help you navigate this. Another situation with that is regards to collective consultation. So currently the parameters for collective consultation is 20 employees at one or more establishment. The government is proposing to remove the one or more establishment, which means that if you have, for example, 4 different sites, you previously would be able to make up to, say, 6 employees at those 4 different sites. You would be able to make them redundant without following a collective consultation process. However, post this change, if it's confirmed the separation of the different sites is no longer standing and the collective consultation would be required because the total number of employees at risk of redundancy is over 20 across all the sites, which would be classed as one business. So what should you do now? We don't know when this change is going to come in. As I said, some things might come in sooner in this October, some might be next October, some could be any time in 2026. But you should begin planning now. If you know that you are going to need to make redundancies or collectively look at reorganising your business, or looking at a restructure, look at it sooner rather than later. Once more details are available, you should make sure you brief your and train your managers on collective consultation, review and update your redundancy practices to ensure that you're compliant, as non-compliance will provide a greater financial risk. And there's also the increased protective award risk that employees can also claim a new right to interim relief as well, which means that they'd be claiming pay whilst they're waiting for the tribunal to happen if they put a claim in. So the risk is that you could get more tribunal claims if you don't follow the process properly. Our job is to help you navigate these processes. So please, as our clients, do come and talk to us. And when you've got any redundancies of any number that you think, oh, you're going to be looking at doing any sort of restructure, and we will help you navigate these new changes. Another change that is potentially going to affect businesses, quite a few with regards to casual sort of work, is those employees on 0 hours contracts. What this proposing is that in 0 hours contracts or low guaranteed hours, who regularly work a consistent number of hours that are greater than their contract, would be entitled to a contract that reflects the hours of work that they do for that reference period. What the government is saying is that there's going to be a reference period on the 0 hours contracts that will regularly need to be reviewed, and if the length of the hours worked during that reference period are not equating to what the contract says, in that they're greater, the employee should be offered that contract with those greater hours. The idea of this is that the government wants to reduce the amount of casual workers and ensure that employees have more security with regards to their jobs, because as you can imagine, if you're on a 0 hours contract but you're regularly working the same pattern every week in, week out, it's not a true 0 hours contract anyway. So they would like that removed so the employee has more security to know that actually those hours are the hours that they're going to work, and that they're entitled to on their contract. So it's a positive for employees in that position. It does have some difficulties for businesses who do rely on 0 hours contracts. If you're using them fully as 0 hours and the hours are changing every week because of the nature of your work, then you shouldn't have any issue, and the reference period would not show that the employee has got a consistent number of hours. So 0 hours contracts 0 hours contract workers, will also gain the right to reasonable notice of changes to shifts and working hours. So at the minute, there's no parameters around that. So the government is saying that they need to have reasonable notice going forward. And workers would also be entitled to compensation should you cancel their shift or shorten their shift, and did not give them reasonable notice that's proportionate to that change. So you also need to be aware that it could cost you a little bit more money to have employees on 0 hours contracts if you're having to pay them compensation because their shifts are being cancelled at short notice. What we suggest you do now is look at, if you're using 0 hours contracts, start preparing, assess the number of workers that are on those contracts, evaluate their suitability and your operational needs. Our first question would always be, what does the business need? What do you require to run efficiently and achieve your strategy? And then from there we can look at, right, how do we put your people in to achieve that strategy? And it might be that you change some people from 0 hours and keep some others on 0 hours because there's roles that require that. It might be that you look at, actually, we need to do a whole change of how the business operates. It might be that actually what you're doing is fine because you're operating the way that 0 hours contracts are designed. But again, look at that, look at the assessor number that are on those contracts, review how their hours are monitored, and make sure that you are able to look back at the reference period. This could be 12 weeks, but that's not been defined yet. And make sure that you are able to plan and manage once these changes come in and comply with the new legislation. So I'm going to pass back to Kim now to take you through some more information.
Okay, so in the topic of flexible working, again, most of you will know that last year in April, flexible working changed. So the government is talking about encouraging more flexible working, so making flexible working the default, a default day one right, except where not reasonably feasible. So it's going a bit beyond what they've already introduced. It's trying to encourage employers to be open to flexible working. So some businesses have been forced into sort of going against the grain, as it were. Originally pre-COVID, everyone was like, flexible working, not really sure about that, not really sure about working from home. And it changed everybody's thought process on it. And obviously it's become the norm for a lot of businesses, us included, going forward. But this is making employers that are a little bit sort of behind the times, as it were, with this, making them think about it, making it become more of a default one right, so that it can't be a blanket ban across the business. We don't like flexible working. It's meaning that employers have to consider it regardless. We don't anticipate these changes coming in before 2026, but of course we will let you know. In the meantime, we encourage you to update your policies and your processes for handling flexible working requests. Revise your recruitment practices as well to include early discussions about flexible opportunities. So it's good to have the discussion, interview stage. If you're open to talking about it, it's, it helps move things along when people get offered the job, that sort of thing. And assess which forms of flexible working align with your organisation's needs. So it might be that you have set days of the week that employees must come into the office. It might be that, you don't allow it for, training, that sort of thing, that you will always have face-to-face training delivered to your team. You need to think about what applies to your business now, and train and support your line managers in the flexible working arrangements. So it's no longer acceptable just to say no. You have to have a really good reason. So it has to be reasonably feasible. Okay, and like we said, we're not expecting it to come in until next year. In terms of equality action plans, again, this is a proposal that requires employers with 250 plus employees to publish an equality action plan addressing workplace inequalities. So this expands on the current employer responsibilities for those already publishing gender pay gap reports. It also links in with the changes that we talked about earlier. But this would add an extra requirement to publish an equality action plan. Again, we're not expecting it until sometime in 2026. It is a good idea to think about these action plans now. Menopause action plans, we have templates that we can send you if it's something that you're thinking about introducing in your organisation. It's a good idea to just get ahead of the changes before they're introduced. And again, we encourage you, sorry, Beck, could you go back a slide, please? So we encourage you to draft your action plans in advance, assess your data needs, capture and monitor the information on outsourced individuals. And like we said, the reporting on menopause will be a new requirement going forward, potentially. Next slide, please, Beck. Family leave changes. So this is maternity and family leave returners with proposed changes. So it's already unlawful to dismiss employees during pregnancy, maternity leave, or within 6 months of returning to work, with exceptions. It expands on this protection for adoption, shared parental neonatal care, and bereaved partners' paternity leave, regulating dismissal post-return. And parental leave becomes a day one right, so it removes that 1 year service requirement. Just to explain what parental leave is, because I think it's still something that most people don't necessarily know that it's out there. It is a statutory law, and it means that if you've got a child under the age of 18, you can take up to 18 weeks of parental leave per child across their lifetime. So it's generally around up to 4 weeks per child per year, and you can take it in blocks of 1 week, and you can have, say, 2 weeks, then change employers and have 2 weeks later on in the same year with a different employer, but you cannot take more than that 4 week statutory right across a year. So that's quite positive that it's becoming a day one right. removing 1 year service requirement. But obviously, as employers, need to be aware of that change. Paternity leave, again, becoming a day one right. It removes the 26-week service requirement, and it allows people the ability to take paternity leave and pay following shared parental leave. Again, we're not expecting it until 2026, but as it's family leave changes, it's potentially going to be introduced around April rather than October. Protection from harassment. So again, if passed as law, employers will have a new duty to prevent harassment by third parties, such as clients or customers. So this relates to the protected characteristics. So we'll talk about sexual harassment in a moment, but this is more around age, disability, gender reassignment, race, religion or belief. It does include sex and sexual orientation, but it's putting more onus again on the employer to prevent harassment by third parties. So making sure that you do your risk assessments, that you have your posters up, that you take as many reasonable steps as you can to prevent this from happening. And if it does go to tribunal later on down the line, you can demonstrate that you've taken all these steps. So the next slide talks about sexual harassment. And many of you will know that we also had a new introduction of legislative change last year with sexual harassment taking reasonable steps, and it got diluted down when it was introduced. So this new employment rights bill means that they're going to potentially revert back to the original definition, which was to take all reasonable steps. So it's going a step beyond, as it were, what they brought in last year. Encouraging employers to take all reasonable steps, again, will mean doing your risk assessments, doing your action plans, putting your posters up, training your staff, making sure your managers are aware that, you know, sexual harassment is not tolerated on your business premises. And again, we're expecting it to be introduced sometime in 2026, but it's likely this will be more autumn than early 2026, and it just continues with what's already in place, just builds upon it. Bereavement leave. So again, quite a heavy topic, I'm afraid. A new day one right will allow employees to take at least 1 week of bereavement leave. This will be a statutory right. We're not sure whether it's paid or not yet. It's likely to be unpaid. If it changes, we will, of course, let you know. And the specific requirements regarding the employee's relationship to the deceased are also still to be confirmed. It's expected to take place no earlier than 2026. Again, we will keep you updated as and when it comes into play. There's also further discussions regarding bereavement leave for pregnancy loss. However, we will update you as and when we know more on this. I think it's been put towards Parliament, but it does keep getting watered down as time goes on. So we're waiting for more details on that. But at the moment, the regulations specify that this particular leave duration must be at least 1 week. However, it will not interfere with parental bereavement leave, which is 2 weeks for a child's death, and will be unpaid. Employees will also be permitted to take the leave up to 56 days after the death of the deceased. So, like we said, the Separate Paternity Leave Bereavement Act, fathers and partners will also have an immediate right to paternity leave following the death of the birth mother or adoptive parent. So that's an additional right again. So there's lots going on here under bereavement leave. So just to recap, a day one right to take at least 1 week of bereavement leave. There's also talk about Paternity Leave Bereavement Act, with fathers and partners having an immediate right to paternity leave following the death of the birth mother. And there's also further discussions around bereavement leave for pregnancy loss, but we would keep you updated as and when we know more. But like I said, it would be 2026 at the earliest. I'm going to hand over to Rowena, who's going to talk about the Fair Work Agency. Slightly lighter topic now.
Thanks, Kim. Another change that the government is proposing is to implement the Fair Work Agency. which is going to be an executive agency of the Department of Business and Trade. Is going to bring together existing state enforcement functions, which are listed on the slide here. So Employment Agency Standards, Scam Masters and Labour Abuse Authority, and HMRC's minimum wage enforcement. And over time, it will take on a wider a range of employment rights that it'll enforce. So this is a single place where workers and employers can turn to for help. The government have stated that further details, including timescales for implementation, etc., will be provided in due course. So it's not something that's in place yet, but it's something to just be on the horizon, that where you'd maybe previously gone for information will change, and you may well be contacted by the Fair Work Agency in the future should they need to contact you for any reason. So hopefully you don't receive a tribunal claim. However, it's always best to know what they are proposing to change. And so the current employee tribunal claims must be submitted within strict time limits. You've got 3 months less 1 day from the date of the event. So for example, if you've been dismissed or just you feel that there's been a discrimination against you as an employee. So you've got 3 months to start early conciliation process of ACAS and a minimum of 1 month to make a claim to the tribunal after receiving the early conciliation certificate. There are some expectations to the exceptions, to the 3-month limit. So at the minute, which is claims for redundancy pay or equal pay, which has a 6-month time limit. But what the government is proposing is that with the amendment to the Employment Rights Bill, there will be an extension to the 3 months, and it will be 6 months for all claims. So this would make changes to claims for unfair dismissal, discrimination, unlawful wage deductions, etc. So what you need to do as an employer is just be really aware of this. Make sure you're on board with knowing how long the timeframes are. If they do extend them, it's likely that you might have an increase of tribunal claims from employees because they've got more time to think about what they want to do. If maybe they've not been able to find employment the way that they wanted to, then maybe that's when they go, actually, do you know what, I'm going to just put a tribunal claim in. So that gives them more time to do that. I would suggest review your processes for resolving individual disputes informally and try and hedge those off before they get to a tribunal, but also assess how you track and manage data that could be related to potential claims. So if there's a longer time frame, you need to make sure that you're maintaining records for that extended period because you may then well need them. As usual, what we would say to you is that if you think that an employee is disgruntled and that they might make a tribunal claim, always try to ensure that correspondence doesn't include their names or is related to them, because you most likely will get a subject access request as well. So if they put a subject access request in, you are liable to provide them with all the documentation that they request, which would normally be things like correspondence, including their names, initials, job role, etc. So if there's anything that's contentious, if you're going to talk to us about it, try and give us a phone call rather than an email, or don't include names, etc. But do correspondence internally as well. Just be very aware of what you're going to send to people, that it could potentially be seen by the individual in the future, and would you want them to see what you've said? And equally, would you want a judge to see that as well? So when it comes to records, make sure that your records are correct so you can defend any claims, and make sure there's nothing in there that you wouldn't want anyone to see. Brilliant. So I'm going to pass back to Kim.
Okay, so we've talked about a number of changes as part of the Employment Rights Bill today. I'm not going to go through them all again because obviously there's quite a lot of detail that we've talked about, but it's probably quite important to note that these legislative changes are possibly in recent years the largest amount of employment law changes that we've seen. So the Equality Act was obviously quite a lot of legislative changes when that was introduced, but although that was a large piece of legislation, some of that was already in place, so this is much bigger and goes far beyond. So it is a lot to get your head around, but please rest assured that we have recorded today's employment law webinar, so you will get a copy of that. following today's webinar for you to review at your leisure. So you can go back through the slides, you can go back through what we talked about. So you don't have to remember everything right now. So the artificial intelligence and employment laws in the UK, on the 2nd of February this year, many of you may not know this, but a ban was introduced on UK businesses using artificial intelligence, so AI outputs, in European Union markets. And this applies to AI-driven decisions in recruitment, performance management, and other employee-related processes. So it's basically saying that you cannot rely purely on AI to make these decisions. So you cannot sift CVs purely using AI. You cannot performance manage purely using AI. You need to have human beings involved in these processes. From the 2nd of August this year, this will also increase further. There'll be a further ban on UK businesses using AI outputs in UK markets, and this will be legally enforceable. And it's ensuring compliance with fairness, transparency, and anti-discrimination laws for AI in employment settings. So it's building on what's already been introduced in February this year, which comes out of the EU laws, but it's been incorporated into UK law as well. And again, it's making sure that if you make decisions using AI, that you also back it up with human involvement. So for a change, as compared to the rights coming in elsewhere, we actually know about these changes and when they're being implemented. So you don't have to wait till next year. So does anybody have any questions? I'm going to hand you back to Alison. I think the rest of the team's going to come online now as well so that we can answer any questions that you've got. Hopefully they're in the chat, ready and waiting.
There isn't any in the questions chat. That means we've done a great job.
Means everyone's saving them for later.
Okay, so obviously apologies for running. Oh, hang on a minute. We do
have one question. Yeah. Can you use AI for job descriptions?
I'm happy to answer that one if you like, Rowena. Yes, you can. You can use AI for job descriptions. You can use AI for a lot of things, really. And personally, I'm quite a great fan of it. When you use AI, though, it's important that anything you create using AI, you then amend. So it might be that you just change one word, but then it becomes your document rather than being an AI produced document. So you need to make sure that you have some human input into whatever is produced. But yes, by all means, you can create job descriptions using AI.
I would just caveat that with the information that Kim just went through with regards that you've got to try and reduce bias, and hence that's the law that's coming in. So just make sure that you're casting your human eye over it to make sure that there isn't anything that you think, oh, I'm not sure on that with regards to protected characteristics, etc.
Yeah. And AI does get it wrong.
We've got another question there from Emma Jane, and the answer to that is yes, Emma, we can get that over to you. We have been refining it because we're also anticipating the October changes, the changes in August.
Brilliant. And Becky's asking, with regards to all these changes, is it a case of waiting to see when they make a final decision on what comes into force and when? So, Becky, I would say yes, but there are things that you can make changes in advance of. So things like the 0 hours contracts, we suggest that if you use those, then start looking at what your business needs strategically. Are they still the right option for you? What is the best thing for your business? So I would look at, although nothing is set in stone with regards to dates and when your action will need to be taken, it's always good to know that these things are on the horizon and just be aware of changes that maybe you're making to your business now and how they might be affected in the future, so that you don't have to make changes twice. Emma's just, sorry, carry on.
I was just going to do. I just wanted to comment further on Emma Jane's comment there. Quite right, Emma Jane. You ought to have a policy there if you have those concerns. We have it internally to police ourselves as well. It's not something that you as a business want to be caught out on. So we'll get that over to you.
Another question is there any issue making changes earlier than when they become law? Who wants to answer this one?
I'm not used to this, Becky. But my goodness me, by all means, yes. And bear in mind for all of you that are retained clients, once you've set through these slides and you want to talk to us about any of this, we can, it's part of the service we offer you. We can support you with that, which is why Rowena was making reference there. But we think getting ahead of these changes is always better, or at least making some baby steps towards it is always better than waiting for them to happen.
Yeah, some of the changes have knock-on effects with regards to other changes as well. So for example, like I mentioned about the fire and rehire, if that comes into force and you need to make changes to your contracts, it might be easier to do that before fire and rehire comes into play. So yeah, we'd always say just strategically work out what is required for the business, and then we can help you with how to implement and when to implement and what else you might need to consider as well.
Okay.
Got another one. If an employee is absent due to their child being ill, should this be documented as parental leave? How is this tracked with amount of days absent with parental leave, with previous employment, etc.? What happens if they exhaust the 4 weeks in a calendar year? With this, what we didn't talk about was a different type of parental leave, because there's no changes coming into that, which is what's called time off for dependents. So that would be when you have emergency leave. So if somebody rings up in the morning and says, oh, my child's got a stomach bug, I need to stay at home, that's time off for a dependent, which is classed as emergency leave. Now that is unpaid by law. You as an employer can decide if you're going to pay it or not, so you just have to have your own policy on it. But that is for a short period of time for them to provide initial emergency care and source other childcare options for that child. In that, it shouldn't be a long-term sort of leave. The parental leave that Kim discussed today is where you book the time off in advance. So it's additional to things like holiday that you might want to book in advance to have time with your child. By law, it's unpaid. Again, if you as an employer want to provide that as a paid enhancement, then we need to talk to you about what that policy would look like before you do anything. So it's the statutory law is that it's unpaid for up to 4 weeks in the calendar year. They shouldn't exhaust it. We would need to be talking to you about that in regards to what that employee is going through and why they're asking for that time off.
I just jump on the back of that, Rowena. So it's quite common for people to request it to cover like school holidays and that sort of thing, because they're struggling to get childcare, and it's quite difficult to take too much holiday in one lump sum. So it might be they use parental leave for 4 weeks of the school holidays, for example, but they would need to give you at least a month's notice in order to take that. And like Rowena said, it is unpaid. And
you need to be able to facilitate it as well as a business. So there's conversations that need to be had around that. Another example is when you know that maybe your child needs to have an operation, so they're having their tonsils removed. If an employee says, oh, my child's going to have this operation, then you could use parental leave for that situation. Brilliant. Have we got any more questions? There have been some good ones, making us all think.
They're very good questions, I think, and thank you all. I appreciate that. Maybe some of you want to ask questions offline. That's fine. Okay, pick up the phone and speak to us. But thank you for your attendance here today. Like I said, it's a special webinar for us. It marks a new chapter in our life cycle, and also thank you for your support as clients. So appreciated. What we want to let you know of next is that for the and it's interesting because the questions have been asked, we felt that there was a common thread to do the next webinar on family leave, which will be on the 17th of June again, and so we will circulate you some invites to that. Please join us on it. And if there are any topics that you would like us to do some webinars on, drop us a line again. We'll work on that and make sure that we're supporting you in the way that you need it. So sorry that this is overrun a little bit, but once again, thank you so much for attending today. I wish you all a very good day. Take care.
Thank you all.
Thank you very much, everybody.
Thanks.